But we will transition now to our next speaker. This is a nice segue into our what's what you said is a 2 o'clock agenda item. Thank you for your patience, Professor Sim Shah of Gonzaga University School of Law. I'm turning it over to Professor Sim Shah.
Well, thank you, and thank you, governors, for having me. I enjoyed listening to that last discussion. I do think it's a great segue into the topic that I was asked to speak to you about today, which has to do with my research on what's happening at the national level with some of these issues, particularly looking at technology-driven legal services and through an access to justice lens. So I don't come to you with any proposal other than to just sort of share an additional perspective and maybe a helpful lens to view some of these issues through. Just a little bit about me. I come from a public interest communications and technology background. I teach professional responsibility and other courses at Gonzaga, focusing on the intersection of legal technology, legal ethics, access to justice, and legal education. In my scholarship, I am a Practice of Law Board member, serve on the Disciplinary Advisory Roundtable, but I'm here with you today in my academic capacity. So I approached these issues focused on technology-driven legal services in particular, and I like to share a quote from one of my colleagues at Gonzaga, Professor Agnieszka McPeak. She says, "Technology has been integrated into the very act of practicing law. The core activity of lawyering, that of thinking like a lawyer, is expressed through the technology lawyers use. At its core, technology is not merely a tool of the trade, but it's wrapped up intrinsically in the very thought process lawyers employ. Modern technology is now entrenched in the core task of being a lawyer, and its function, purpose, and future potential cannot be ignored." So we see this reflected in the evolution of some headlines over the last few years. Several years ago, back in 2020, a lot of the discussion was on the self-help front, right? Would you trust a lawyer bot with your legal needs was one headline. Looking at services like Do Not Pay and some other technology-driven services that are largely used in lieu of someone seeking licensed legal professionals. More recently, though, we've seen lawyers' own use of technology being the subject of headlines. So one that I'm sure many folks are familiar with by now is the New York lawyer who used ChatGPT and some of ChatGPT's hallucinated cases in a brief that was filed when in fact those cases did not exist. And when asked to go back and see if those cases actually did exist, the lawyer went back and asked ChatGPT again, are those cases real, and sort of doubled down, which led to some sanctions from the court. We're seeing courts respond to instances like these. So a Texas judge recently added an additional certificate that needed to be filed, certifying that either no portion of any document that was filed with the court was generated by an AI tool like ChatGPT, or that if it was, a human being had checked the AI generated text. So we're seeing really a really fast adoption of, or at least use of, some of these tools, and a response when some of the headlines are problematic. Just a quick international perspective, a Colombian judge actually recently said he used ChatGPT in helping him reach a ruling. Not that he relied entirely on the tool, but that it was one thing that he turned to in reaching his decision. Whereas the discussion at one point was framed around robot lawyers replacing lawyers, what we're really, I think, dealing with, and is becoming increasingly clear, is that we're not dealing with robot lawyers as much as a cyborg legal problem-solving landscape, one where we have a diverse array of stakeholders. We have consumers, we have licensed lawyers, we have other licensed legal professionals, and increasingly non-lawyers and other third parties, including technology and AI vendors in this landscape. I think one way to look at this issue is looking at the law as an industry. And obviously there's things about the legal industry that make it unique in its self-regulation and in some other aspects, particularly concerning the professional responsibility and the rules that lawyers are subject to. But the legal services industry hasn't adjusted regulation in response to new technologies in a way that we've seen other industries do. So, for example, just thinking about healthcare, And for example, HIPAA, state health privacy laws. We could think of the FDA and its cybersecurity procedures during pre-market approval of medical devices. On the educational front, we have FERPA and the Protection of Pupil Rights Amendment. We have state student privacy laws. And in the consumer setting, with the Federal Trade Commission and federal data privacy laws and enforcement mechanisms, as well as state privacy laws, we haven't seen similar responses from the legal industry. And again, we don't always compare ourselves to other industries, but is there something that we're missing? Is there some opportunity that we could seize in order to respond to some of these technologies more effectively? So that's where my research has been focused. I published an article last year looking at the landscape and concerns that actually an increased reliance on technology could perhaps exacerbate the justice gap if not designed, adopted, and used effectively. My recent article that just came out last month is looking at the issue of potential regulatory reform driven at the national level, which I hope will add an additional dynamic to some of the things we've been talking about today. Going forward, I'm looking at these issues more from an international and comparative perspective, and what we can learn from experiments that have been done around the rest of the world. I hope to touch on all of these just briefly. But I do approach these issues from an access to justice perspective, through an access to justice lens. Obviously, it sounds like it's been discussed frequently today, and I know I don't need to convince everyone that there is an access to justice gap in the U.S. and in Washington State. At the national level, the Legal Services Corporation reported last year that low-income Americans don't get any or enough legal help for 92% of their substantial civil legal problems. The justice gap is exacerbated by economic recessions, and as we're increasingly seeing by the COVID-19 pandemic, with data suggesting the income disparities and the justice gap between low and higher income Americans are exacerbated for pandemic-related civil legal problems. And as has been alluded to, an increasing number of voices acknowledging that we're not going to human our way out of this. Dina Homonis, from former Supreme Court justice from Utah, Dina Homonis, has said empirical results conclusively demonstrate that we can neither volunteer ourselves across the gap nor rely on public services. And academics and others have said that modest solutions are not likely going to offer us the sort of revolutionary change that's needed for the delivery of legal services today. This all led the Georgetown Law Center on Ethics in the Legal Profession to declare that closing the access to justice gap is going to require both incremental improvement, but also that breakthrough change that we've been talking about. So within this kind of landscape, then, this narrative has emerged that, of course, legal technology could be something that could help close the access to justice gap, whether it's democratizing access to information or increasing efficiencies in legal research, legal analytics, document generation, and other means. Could this ultimately decrease costs? Could the unbundling of legal services make them more affordable and more accessible? To the extent that we could help people who are inclined to help themselves, could technology help? Could technology also help people realize when they have a legal problem and connect them with attorneys, and ultimately allow existing services to reach previously untapped markets? So that's one vision for technology, but by no means is that vision guaranteed to actually lead to a decrease in the justice gap. And in fact, concerns have emerged that an increased reliance on technology, if not done carefully, could actually exacerbate the justice gap through the creation of a two-tiered system of legal services. So in my previous article, I've looked at what those concerns are. And I've identified really three sort of versions of that concern. One is that there could be, with an increased reliance on technology, a relegation of some consumers to what actually would be viewed as, or even in fact be, an inferior technology-driven solution, even in cases where human-driven assistance would be more appropriate. And the idea that would not actually meaningfully improve access to justice. Another concern expressed is that almost the opposite, right? The technology-driven services, at least when combined with human services, would actually lead to superior services. They just wouldn't be evenly distributed. Whereas large law firms might be able to invest in these technologies and deliver superior services, others across the landscape, especially those aimed at closing the justice gap, might not be in a position to do so. And the third concern is that technology just isn't going to meet our expectations. It's not going to make the kind of change that we've envisioned, and what we'll actually be left with is the two-tiered system that is the status quo, where some can and some can't afford access to legal services. So overcoming these challenges, steering technology down the path where it could reach its promise, its potential, and avoid that perilous path, it's going to require calibration of legal technology, including artificial intelligence, calibration of it toward access to justice. So in my work, I identify 3 access to justice calibration considerations that are going to be essential to steering technology down that path. One is consumer considerations, acknowledging that we can't just throw technology at someone and expect them to make effective use of it. Many consumers have aversions to technology. We still have a digital divide, and many consumers have an aversion to seeking legal services for one of many reasons. And technology might not necessarily be the thing that bridges them to bring them into the legal services landscape. So keeping those considerations in mind from a consumer perspective, there's also issue considerations, right? There may be some issues where we would be more resistant to turning some aspects of lawyering over to technology. Whereas uncontested divorces and parking tickets and some of the examples that we hear about might be appropriate for an increased reliance. When life and liberty are on the line, we might show more restraint. And then there's task considerations. This has sometimes been criticized as being reduced to something that's been called HABA-MABA, which stands for humans are better at, machines are better at, and oversimplifying this sort of false dichotomy between the two, when really it is a more complex, nuanced analysis that involves considering those issue considerations and those consumer considerations, alongside with the question of, are there certain lawyering and legal problem-solving tasks where less reliance on technology is warranted? And I think the headlines that we're seeing with ChatGPT and some of maybe the ill-advised reliance on it for certain tasks, whether it's legal writing or aspects of client intake or strategy development, are there certain tasks that are maybe where maybe we should be more cautious? So those calibration considerations are critical for steering technology down the path that would improve access to justice. But in my work, I also identify barriers to those access to justice calibration considerations. One is resource barriers. So to the extent that technology could be helpful, it's expensive. It's expensive to develop. It's expensive to implement. It's expensive to oversee. Oftentimes there's startup costs that are underappreciated, and certain ongoing maintenance costs that are underappreciated, not to mention the cost of human expertise to help maintain these systems and use them effectively. There's also resilience barriers, though, right? The development of these technologies in a way that's going to improve access to justice, there's going to be inevitable failure along the way. And whereas some legal problem solvers might be in a position to weather those storms and work through those challenges, others might see that sort of necessary trial and error as something that's prohibitive to really going down that path and exploring some of those options. And then maybe the most serious is the relationship barriers. So as you know, as I think we can see, these are interdisciplinary endeavors in order to account for some of those access to justice considerations, calibration considerations. These have to be interdisciplinary pursuits. They have to be cross-industry pursuits. There have to be ongoing dialogues between lawyers and social scientists, computer scientists, and others who can help account for some of these other challenges, right? Maintaining our expectations with technology, working through the transparency issues and the fact that we're really dealing with black boxes a lot of the time, especially when we deal with something like ChatGPT, for example, where even the designers can't tell you why a certain output was the way it was. Technology is great at telling us what's common. It's not necessarily great at telling us what's good or best, especially for a particular client. There's also bias concerns, right? In law, we rely on data from the past. Data from the past is going to not necessarily going to reflect where we want society to go all the time. And so there could be this data-driven conservatism, which isn't to say political conservatism, but rather an adherence to the status quo, automating what's happened in the past and what's common rather than challenging what's common and asking what's best, including for individual clients. And then, of course, there's data protection issues that's going to require expertise from people outside of the law. So there's regulatory uncertainties, of course, in this landscape, and I know this group is probably more familiar with these than most, right? We've been discussing, do certain uses of these technologies, depending on who's involved, amount to the unauthorized practice of law? To the extent that a lawyer is involved in helping designing them, would the lawyer be assisting with the unauthorized practice of law? Would use of certain technologies lead to discrimination? Would we be adequately protecting client data with some of these uses? Would certain uses be violating the duty of technology competence? And would those relationships that are required in order to effectively design and adopt and deploy these technologies, would that require a prohibited fee sharing arrangement, or would that require a cross-industry business structure that's currently prohibited? The response to this regulatory uncertainty across the country, well, we've seen, of course, in a slow implementation of the ABA's 2012 amendments to its model rules from the Commission on Ethics 2020. Those amendments took into account new technologies, but really cloud computing was like the new buzzword of the day in 2012. And a lot of the amendments were aimed more at those questions relating to cloud computing, as opposed to, say, artificial intelligence and ChatGPT and some of the emerging technologies that we've seen in more recent years. As we've discussed, as I heard mentioned a couple of times in the last session, Arizona repealed its Rule 5.4 restrictions on non-lawyer ownership, essentially without going through any type of regulatory sandbox or anything like that. But we have seen legal regulatory sandboxes or laboratories or data-driven legal regulatory reform, whatever label we want to put on it, seen them proposed in many jurisdictions. Of course, Utah was the first and the one to actually have an ongoing sandbox in practice. Obviously, we've been discussing something like this in Washington, the idea being we offer temporary safe harbors to carefully vetted and subject to careful oversight services that would currently run afoul of certain rules or regulations, with the idea of carefully monitoring them, generating data, and then basing regulatory reform decisions on that data, rather than simply relying on anecdotal evidence, which has been the practice to date. So, but we've seen resistance to sandboxes or labs or data-driven legal regulatory reform in many jurisdictions that have proposed them. Some of that resistance has been process-oriented, right? Who's going to actually oversee this? What's actually going to be done? How are we going to do this? How are we going to maintain it? There's been substantive resistance as well. The idea that I don't care what the data is going to say. I don't think we need to be exploring this process, because I don't think we should change. Don't think we should change the way that we currently regulate legal services. But I think a recursive theme, and one that was mentioned a couple of times in the last session, was this lack of data. The fact that these decisions aren't currently data-driven, and states that are trying to move toward data-driven reform are running into some of these challenges in overcoming that. So I'm asking the question in my research then, right? Could there be some benefit in elevating some of this legal services regulatory reform, some of these processes, beyond the current local level? And what do I mean by that? Well, could we be moving toward a future where some type of nationally driven data-driven legal regulatory reform be something that jurisdictions would be interested in. This might take the form of a national legal services regulatory sandbox. So before I go into just a little overview of what that might look like, some of the initial pushback and initial reactions to even thinking about something like this is, well, we don't do this on the national level. We do this on the local level. And it's not entirely true because jurisdictions already outsource some key parts of licensing to national organizations. Whether it's, while still maintaining control, right? We can outsource the design of the bar exam and set our own cutoffs on what the scores would be. We can outsource accreditation of law schools and still require that those who are licensed in our jurisdiction attend one of those schools. And we can outsource the character and fitness evaluations and rely on those in our licensing processes. So it's something that we do even in areas where we're highly critical, right, of the bar exam often and character and fitness evaluations and the like. Jurisdictions also don't often draft their rules of professional conduct from scratch, right? A lot of them are based on the model rules of professional conduct. So we already outsource some key parts of licensing to national organizations. And again, even though the legal industry is different from many others, a shift toward at least looking at regulatory reform being driven at the national level with regard to legal technology could shift the legal profession more and make it more closely aligned with other industries that are benefiting from the efficiencies and the expertise available through national regulation of relevant technologies. Under this idea, right, states would still retain regulatory authority. They would just have fewer burdens along the way. So what would this actually look like? Well, it would mirror what Utah's done. It would mirror what's been proposed here in Washington. A national organization could solicit and evaluate and admit applicants for participation in a national sandbox or lab. Through careful vetting and screening for potential harm to consumers and some of the things that we've identified in considering such a move here in Washington, recommend that jurisdictions then authorize temporary safe harbors for admitted participants accordingly. Nothing would require a jurisdiction to do that, but the jurisdiction could more readily get to the point of making a decision about whether such a safe harbor would be warranted, rather than have to build the sandbox from scratch necessarily. The national sandbox could then monitor the performance of the participants operating in the sandbox, including by collecting that relevant data, issuing update reports along the way to jurisdictions that have opted into this. And at the end of the day, the sandbox could recommend long-term licensure reforms after a participant's term in the sandbox has ended. The implementation of that would still be on the state, right? Whether it's a Supreme Court order, whether it's some other process that would actually lead to temporary or longer term reforms would be up to the jurisdiction, as is currently the case. But could that process of gathering the data and overseeing the entities be something that's explored on the national level? A second step to this, if such a national driven process emerged, could be the incorporation of more international and comparative perspectives into national data-driven reform processes and related discussions. So this wouldn't be by any means a uniform law, but rather it'd be another source of data based on experiences, successes, failures, uncertainties, and perspectives that have emerged from other countries that have undergone similar experimentation. Obviously, we would have to appreciate the differences in regulatory histories and structures and values between those different countries. But other countries do engage in more experimental and interdisciplinary and collaborative reform efforts than in the United States. And many legal technology trends don't cross borders. A lot of the challenges are the same. So we would by no means be operating as a blank slate, and the national level might be a more conducive environment to taking into account some of these perspectives than at the local level, where some of the resources are more strained. We do have existing dialogues and forums along these lines. The International Legal Technology Association has been looking at these issues. The International Conference of Legal Regulators has been tracking some technology topics in some of its work. And existing reports, I think, support the idea that U.S. Regulatory experimentation would be warranted. A lot of fears about sort of what impact reform would have on existing legal services turned out not to actually be the case in some other jurisdictions. And existing international data and methods could inform what type of reforms should be tested and what data should be collected, particularly concerning access to justice in the U.S. So, so national experimentation could provide the audience and the infrastructure for future comparative reports to have a greater impact. So I moved through that quickly. I figured there's been such great discussion so far. I'd be happy to turn it back to the group. I know you have more on your agenda to do, but thank you for having me, allowing me to share some of these ideas with you, perhaps offer an additional dynamic and perspective to view some of these issues through. And I'd be happy to stick around for a few more minutes if folks have any more questions. Otherwise, I'll turn it back to you. Thanks again.
Thank you very much, Professor Simshaw. Congratulations on the publication of the Court of Law Review. I'll turn it over to the board members. Questions or comments with Professor Simshaw? Jordan first.
So this might sound like a leading question, Professor Simshaw, with our history of all this together, but I promise you it's not. As you were talking about the kind of danger of a two-tiered legal system, I had flashbacks to the access to justice technology principles adopted by the courts a few years ago. And I'm curious, are those justice principles something that we think should be, or that you think should be brought out, dusted off, and either updated or incorporated into a potential RFP for a beta test of legal regulation in Washington? Like, should those principles be taken and added into something we're doing that's looking at regulating entities as part of this?
Certainly, and I think I think we could even broaden it. Yeah, we don't have to by any means recreate the wheel here. I think those principles, I think even looking outside of the legal industry, right? There's increasing. I mean, the White House just put out another set of guidance within the last couple of days on artificial intelligence, and a lot of those existing principles, I think, could be the starting point for helpful guidance in this area. Absolutely.
All right, thank you, Jordan. Thank you, Professor Simshaw. We'll go to Brent next, who I see on Zoom. Again, scanning around the room. I mentioned I'm going to ask for comments from the governors. Obviously, any comments or questions from staff are invited as well. So everyone.
Thank you, President Abel. And I just do want to point out that Professor Simshaw was also a member of the Husky Marching Band. And I think I see on the bulletin board behind him there. So he has been an exceptional person that I've known for, we won't say how long. But I do have a question, because something real just happened in my practice this past week, where there is a free access to justice service for powers of attorney documents. Unfortunately, it's defective. And now the real harm is that a bank has refused to honor it because it violated the notarial act of, I mean, it's the dumbest thing. It was notarized and stamped, but the RCW 4245-140 says it must say the name of the person in the notarial stamp. And so a large multinational bank refused it. Now I've sent a message to the people responsible, and we're hoping to fix that. But my concern is, and I think this was like in the third or fourth slide of yours from the very early part, where we're talking about the access to justice component of where we're going. But when you have so many substantive laws that are different state to state, I mean, you've got the Uniform Power of Attorney Act that we have in Washington, but then it also, it says you can have a power of attorney that's either notarized or witnessed by two people. But then if you have it notarized, you think, oh, that's easier. And then you have the whole notarial act that you have to comply with. I mean, so how do you see that component with anything that's on a larger scale, when we're still going to be 50 states plus territories that have all the different jurisdictions that have their own substantive laws that, yeah, this is going to benefit multinational bank X and company, but it's really going to decimate the local stuff.
Oh yeah, so sir, I mean, I think the legal complexity is one of the things that makes those calibration considerations, I think, especially critical, right? I mean, it's one thing to it's one thing as a human-driven law practice to understand the law and appreciate those nuances. It's another to try to account for that in any form of automation or any type of service that's relying on technology to take on part of that process. So on the one hand, I think the challenges underscore the need for those types of, oftentimes that's a technical question in terms of how we can use technology in a way, or maybe that's an area that we identify as staying away from technology. But I think also behind your question too is it smart to move toward the national discussions when there's these local variations in local variations on those laws. And I think I think the benefits of the data-driven reform process is, to the extent that those challenges exist, to the extent that harm could result, it's brought to light. Either through the vetting process or through the careful oversight with data reporting, the natures of that challenge can actually be brought to light, be less anecdotal. The application process could account for detecting those things in the first place, or it could account for how you would respond to those challenges when they arise. And the transparency in the discussion of identifying and responding to those challenges could help address them more on a national level.
All right, thank you, Professor Simshaw. We will go to Kevin next.
Thank you, President Abell. I'm going to partially answer Governor Williams' brief by pointing to an existing computer program you can buy called TurboTax. TurboTax will take you through possibly the most complex piece of legislation in the world, which is the United States Internal Revenue Code. But for people who live in states that have state income taxes, which are hardly uniform, they'll do your state income tax forms as well. It's perfectly possible for a well-heeled provider to put work in so that the legal engine that produces the documentation does a good job. It can happen if there's enough, time, effort, and money put into the effort. The flip side of that, I am distressed by your anecdote on the deficient power of attorney. In Washington today, there is no requirement for that provider to fix it. There's no requirement that the power of attorney you put up on the interweb to help out other people be good. We can't regulate it because they're not members of the bar, unless the person who posted it is a member of the bar. We can go after them for malpractice, I suppose. But we have to fix the second part before we can ensure the first part.
All right, thank you, thank you, Kevin. Professor Simshaw, do you have a response to that? We've got other folks with questions, but I didn't want to cut you off in case you had a comment, want to make a response.
Oh no, that's okay. I was appreciated the comment. Yeah.
Okay, thank you very much. We'll go to Advancement Director Platchey, followed by Tom.
Thank you, and thank you for your presentation, Professor Simshaw. We've been kicking around some of these conversations about national regulation internally, sort of in the context of this regulatory sandbox that's been talked about. And certainly because some of these technology companies obviously are operating in all 50 states. I assume some are operating internationally to some extent. My question is more around how you would propose this be implemented from a national level. I assume we would want to keep this regulation under the judicial branch somehow. So are you advocating that there be some federal agency assigned authority by the U.S. Supreme Court or something else? Like, what's the mechanism for how this would stay under the judicial branch and how it would be overseen?
Right. Yeah, I think the actual implementation of any reforms and the actual implementation of any safe harbors would have to still be done through the judiciary on the local level. So I would see this more as resembling the model of the development of the rules of professional conduct, right? A national organization gathering national expertise, which isn't to say this is the perfect system, just to say that we do this for other things, but a national organization pooling funds, pooling expertise. Grants grants could be centralized as opposed to being spread among the 50 states. But a national organization that oversees that process so that the states don't have to recreate that mechanism at the local level. But the implementation of the safe harbors, the eventual reforms themselves would have to be done, at least under the way I'm seeing it, using current local mechanisms.
Thank you.
Thank you, Professor Simshaw, and we will go next to Tom.
Just to follow up on Brent's example and Commissioner Fay's, Governor Fay's comment that there's no way to go after it, it's not illegal or anything. I'll just say the three letters that I said before, CPA. Unfair training practice, that would be your legal remedy. The problem is, it's such a good amount of money that.
Well, it's the program is free. So,
It's in the sphere of trade or commerce. It's commerce, it's in.
All right. Thank you very much, Tom. Other questions or comments for Professor Simshaw? We're not quite right against time, but we're getting close. Any other questions or comments?
Yeah,
Todd, thank you.
yeah, this is interesting. I like the Governor Fay's commentary regarding to tax prep software, but clearly in that situation, 100% of people who are learning on Facebook line their tax preparation software. Not everybody needs power attorneys. Not everybody needs. I mean, maybe that's arguable. These wills, trusts, etc. Other types of drafted documents. But the other thing is, we look at access to justice. Part of drafting and forms and things of that nature are, clearly there's a need for that, but this, doesn't really have any impact on representation, which is really where, a lot of times rubber meets the road. This is going to do much for, small town and rural type issues. Defendants who need representation or people who have civil litigation needs and things of that nature. So, it seems it's kind of a mixed bag. The other thing is, I there's the National Conference of Bar Examiners, there's the National Association of State Bars, if I'm not mistaken, which would potentially be, it seems like the type of organizing entity that could kind of sponsor or kind of drive this conservation or regulatory effort. So, it seems to me as though there are some solutions and answers, but again, the market, for example, federal income tax versus state by state POAs, how many work there to derive that kind of thing, and particularly, we see uniform laws have so many different 50 different variations on the uniform law, and it makes it a real challenge.
All right, thank you very much, Todd. Well, we are pretty much at time. I want to thank Professor Simshaw very much for being with us here today. Thank you so much for